Hi, today we're going to be talking about a no-case submission application in a criminal trial. So, at a criminal trial, after the prosecution has made its case and has tried to discharge the burden it has of proving the guilt of the accused person, before the accused person opens his own defense, starts to make his own defense, he has an opportunity to make an application, which we call a no-case submission. And a no-case submission is basically an application that is made by an accused person whereby he would be saying to the court that there is no evidence on which he can be convicted, all right? That there is nothing the prosecution has adduced that satisfies, that discharges that burden on them. And therefore the court should end the case, that he does not have the obligation to go ahead and prove his innocence, because remember that in a criminal trial there's a presumption of innocence, and so it's the job of the prosecution to prove the guilt of the accused person. It is not the job of the accused to prove his innocence. So when he makes this application, you see that it may succeed in certain circumstances. It may succeed if the prosecution has failed to prove the ingredients of the offense of which he was charged. For instance, if they failed to prove that there was that intention to kill in the case of murder. It will also fail if the evidence which the prosecution has adduced has been thoroughly discredited on that cross-examination. And it may also fail if the evidence is manifestly unreliable that no reasonable court would convict upon such evidence. All right, so on any of these grounds, a no-case submission application would succeed. Now, where a no-case submission succeeds, the effect it would have on the trial is that it would lead to a discharge. But this is a discharge on the merit, and therefore it amounts to an acquittal. All right, it is a discharge, but it's a discharge that's on the merits of the case, and so it amounts to an acquittal, except in the magistrate court in the north, where it remains a mere discharge. And of course, you know that the difference between a discharge and an acquittal is that a person who's been merely discharged can be retried for the same offense, but the person who's been acquitted cannot be retried again for that same offense based on his right to not be tried a second time for an offense for which he's been tried for before. So that is the effect of a successful no-case submission application being made. Now, what happens where the court overrules the application? If the court overrules the no-case submission application, then the defendant, the accused person, would then need to proceed to make his defense. Now, when the court is making such a ruling, it is proper that the court should make it as brief as possible. All right, the court should not make a lengthy ruling and should especially not go into commenting on the evidence adduced by the prosecution, because since the court would still need to hear from the defendant, it's important that the court remains that position of an unbiased arbiter and does not further its discretion by seeming to suggest that the prosecution has basically proved irrefutably that the accused person is guilty. So it should be short, and the court should not comment too much on the evidence adduced. Now, if the court rules in error against the no-case submission application, all right, overrules it in error, and compels now the accused person to go ahead and open his defense, and while making his defense, an accused person somehow incriminates himself. Now you see that such conviction would be overturned on appeal. Why? Because he's only incriminated himself as a result of the court wrongly overruling his no-case submission. All right, because the evidence on which he was convicted is evidence that was given by him and not really by the prosecution. So he was right when he said that the prosecution failed to discharge the burden, and as such, the court should have ended the trial. So where you have such a conviction reached, after a no case submission was wrongly ruled, such conviction will be overturned on appeal. And that's a few things to know about the no case submission application in a criminal trial. I hope you've enjoyed learning. I'll see you some other time. Bye.